Good morning and welcome to Training Thursdays for the month of July. For those of you who are new to the webinar, or for those of you who are new to me, my name is Hermie Abraham and I am an employment lawyer with Advocation Professional Corporation. We are an employment law firm and we assist both employers and employees help resolve their workplace issues. And one thing I believe in is proactive resolution. So anything that you can do to be able to stop a problem before it happens is better than addressing problems when they do happen. And that's part of the reason why I developed Training Thursdays. It is a way of answering some commonly asked questions and being able to have easy to find, synthesized information about some aspects of employment law that aren't readily known or maybe available. So as far as the format, these webinar series are held on the third Thursday of each month at 9:00 a.m. And they last for approximately 30 minutes, which includes a chance for you to ask questions at the end. I do encourage you to ask questions if you have any, either at the webinar or send an email to me afterwards. And with respects to the webinars, there is a new topic each month. This month, obviously, we're talking about the Employment Standards Act, but next month we will be looking at the Accessibility for Ontarians with Disabilities Act. So it will cover a myriad of workplace issues, and I'm sure you'll find the content useful and helpful. A few housekeeping issues before we begin. We are using the Google Hangout platform. And as a result, for those who have attended before, this will be a reminder, but for those of you who are new, there is a slight delay. So if you are to pause the webinar as it's happening, you'll be able to pick up from where you left off, but you will not be able to be live any longer. So if you're asking questions, the webinar might have already ended. So that obviously creates a bit of an issue. And there is also a bit of a delay in terms of my interaction as well. So I'll try to be on time as much as possible, excuse me. But there might be a bit of a delay in terms of the timing of the slide, so don't mind those issues. So today, as mentioned, we are looking at the Employment Standards Act specifically. And I picked the Employment Standards Act because it is one of those legislations that everybody's very comfortable with and believe that they know, but there's lots of little quirks and idiosyncrasies with the Employment Standards Act that's always worth getting a sense of and being able to better know. So I've loaded a poll to find out if your workplace has been the subject of a complaint or investigation, so please do provide your answers. The format of the webinar today, we will be going through some of the top violations that are discovered during an employment standards workplace inspection, and just discussing best practices to ensure that there has been compliance within the workplace, and what you can do to be able to better achieve compliance within the workplace. So your polls are coming in. I'll say this with the Employment Standards Act. It's one of those pieces of legislation that I myself even consult because, again, like I said, there's lots of really tricky pieces about what you should be doing and what you shouldn't be doing. And so it's always helpful to have a good sense of what the legislation actually requires, because that's what the employment standards investigators are going to be focusing in on. So taking a look at the Employment Standards Act by numbers, for those of you who've read some of my blog posts, you'll see that there are two ways that the Employment Standards Act is enforced. One is through complaints investigations, and others are through targeted inspections. And complaints investigations are the greatest percentage. We'll see that 17% of people have said that their workplace has been subject to an ESA complaint. And I should say, I should have asked for people who assist workplaces, because I know there's a number of HR consultants who are on this call, and they assist many workplaces. But it's very common that employees make complaints to the Employment Standards Act, whether those complaints are valid or not. And the Employment Standards officers investigate those complaints. So by and large, those make up the majority of complaints. Sometimes employers required to participate, and other times they are not, because the complaint might be frivolous or there's nothing to it and it can be dismissed. But the issue with having a complaint is that you're then on the sort of target list of the Ministry of Labor, especially if there's a series of complaints, and then they start doing targeted inspections. Now, targeted inspections don't only happen to employers who might have received complaints in the past. They also happen to different types of industries. So, for example, industries that employ youth workers or interns are now the subject of an inspection that's going through, actually just finished on June 30th. So they target workplaces to find out if they have interns, and they try to see if these particular workplaces are complying with the Employment Standards Act. As well, there are different other facilities, such as daycare facilities, fitness centers, manufacturing organizations, that also tend to be targeted by the Employment Standards Act and come up in these targeted inspections. As far as fines and penalties, I'm just going to make, I have another poll that I've put up, and I will share the results of the poll with you. But in terms of fines and penalties, you'll see that from 2006 to 2012, which are the only stats that are available online, there were 2,732 convictions. And I called to see if there is more current information. That's all that they have right now. And if there is a conviction, there is a fine of $295. And then, of course, the employer has to remedy any other type of issue that has acquired. So if it was, let's say, an overtime infraction, they'd have to pay the overtime in addition to the fine. If the employer fails to comply with the orders that are given by the Employment Standards Officer, then the convictions and penalties can become far more serious. For an individual employer, it can result in a fine of $50,000 or up to 12 months of imprisonment, or both. And for corporations, they can have fines for up to $500,000 if they've had 3 or more convictions in past. So they can be very significant. And again, you don't want to be on the radar of the Employment Standards Act and the Employment Standards Officers. So with respect to the poll, I asked which of the following was a top employment standards violation discovered during targeted inspections in 2012 and 2014. Most people thought that it was record keeping, and there's an even amount for vacation, overtime, public holidays, and hours of work. In fact, the top violation was with respects to public holidays. Public holidays is one of those areas that has lots of, again, quirks and idiosyncrasies in terms of how an employer should be complying with the Act. Next was record keeping, as you would expect. Overtime pay is the third. The fourth was vacation pay and vacation time. And the fifth was hours of work, and whether or not the employee is exceeding the daily or weekly excess. And so this webinar will cover all of those topics. So we'll start first with public holidays. And where employers fail to comply specifically, and this is true for many other areas of the Employment Standards Act, is the employer doesn't have a written agreement with respects to the way public holidays should operate. So for example, the Employment Standards Act says that if an employee is working a public holiday, they can have pay and a half that particular public holiday, or they can have an alternative day off. Now, if that's not in writing, that the employee can have an alternative day off, and the employer gives it to the employee, even though it's not in writing, that would be a failure under the Employment Standards Act. So it's important to have written agreements with respect to public holiday, and that's one area where employers fail. Now, I will say this, I will talk about best practices at the end, but I will provide you with a tip sheet, as you know, for people who've attended the webinars before, I provide a tip sheet to registered attendees with some best practices for you to help manage your workplace. So a lot of the best practices will be included in this particular tip sheet. The other issue that employers run into with the public holiday and public holiday pay specifically is thinking that it is only based on 1 day of an employee's pay, and that's not true. So you're not just giving them 1 day of pay. There's actually a calculation for the way public holiday pay is given, and it includes the employee's regular wages, and so it could include tips, gratuities, bonuses, and commissions. So they're the regular wages that the employee has earned in the 4 weeks before the public holiday, so the 4 work weeks before the public holiday, and it's divided by 20. So for an employee who earns a set amount on let's say annual basis or weekly basis, it doesn't change. There's no tips or gratuities, there's no commissions or bonuses, then there's no issue with respects to the calculation of public holiday pay, because it ends up being just a replacement of 1 day's worth of pay. But if you have bonuses that are paid in advance of a public holiday, or if there's tips and gratuities that are included, then the calculation obviously would change. As well, if there's an employee who works variable hours, a part-time employee or a casual employee, then that particular person's public holiday pay calculation is not going to be just average day of pay. It's going to be the 4 weeks, the average of the 4 weeks divided by 20, the 4 weeks added up divided by 20. So it's important to know that that particular calculation with public holiday pay. And the last issue with public holiday pay that employers have issues with is the last and first rule. And the last and first rule sounds probably a bit more complicated than it is, but it really just means that an employee is entitled to public holiday, having the public holiday off, if they worked their last regularly scheduled day of work before the public holiday, or they're going to come to work on their first regularly scheduled day of work after the public holiday. And so where this trips employers up is an employee who is a part-time worker, let's say, and let's say they only work Monday through to Friday, and we have a civic holiday that's coming up Monday to Friday, or maybe they only work on, let's say the employee works, sorry, I'll change this. They work Wednesdays and Thursdays only. We have a civic holiday coming up on a Monday, and the employee doesn't typically work that particular Monday. Because the employee is working their last day before the public holiday, the regular shift, or their first day after the public holiday, either or, they're still entitled to a day off. So they're entitled to a public holiday, even though they don't typically work on that public holiday date. Also, employees who are on a leave of absence, they would be entitled to the public holiday as well. And it would also apply to employees who might be on a maternity leave. So that public holiday provision of the day, as well as possibly providing public holiday pay, exists for employees who might not even be scheduled to work that particular day, and not scheduled just because not because they were on vacation as well too. And vacation employees are entitled to have the alternate substitute day given to them. And remember, if you're giving an employee a substitute day, it has to be in writing. You were not able to just give them a substitute day on the fly. So you'd have to have something in writing. And if there's an inspection, that's what the Employment Standards Officer would be looking at. Now, in terms of the public holidays, there are 9 public holidays in Ontario. Most people got it right. The civic holiday is not a public holiday. Thanksgiving is. And what this means for the civic holiday is that, and I use it as an example, but only because it's upcoming. I guess I should have used Labor Day instead. But with the civic holiday, employers can give the employees time off work. They can give it as paid time off work if you want to do that as a benefit to your employees, but there's no legal requirement to do so. However, if you've been doing it in past and you're looking to make changes now, the Employment Standards Act does allow employers to give a greater right or benefit to employees. And so if you've been giving the civic holiday off as a paid holiday, then you would have to continue doing so unless you changed your policy and made it very clear and gave enough notice to employees of the change that was coming down. So moving on to the next area that creates issues within the Employment Standards Act, overtime and hours of work. Now, with respects to overtime and hours of work, some of the main ways that employers run afoul of the Employment Standards Act and end up not passing Employment Standards Act inspection is that they fail to establish daily, weekly, maximum hours of work. And the law states that there is a daily maximum of 8 hours. So an employee cannot work more than 8 hours of work per day. Now, note that those hours of work don't include breaks, and they don't include lunch periods, which are unpaid time. So presumably an employee can work a longer day, but as far as paid hours of work, they can't be more than 8 hours. On a weekly basis, there is a limit of 48 hours. And if an employer wants to exceed either the daily or the weekly limit, they can do so, but again, they must have it in writing with the employee's consent, agreeing to that particular time. And also with respects to the weekly hours, they have to have approval from the Director of Employment Standards. Many employers and workplaces don't, but understand that to comply with the Employment Standards Act, you would have to have the approval of the Director of Employment Standards if you wanted your weekly hours of work to exceed 48 hours. Now, overtime is only provided on those hours that are worked in excess of the 44-hour work week, and overtime pay and a half. So it's important for employers to understand that if you are saying that your work week is 40 hours and you're giving a salaried employee pay based on 40 hours a week, if they are required to work up to 44 hours, you technically do have to pay them for those additional 4 hours because they are now working overtime. However, you don't have to pay them at the rate of time and a half. Time and a half only applies after they have worked 44 hours. So the best practice and a policy that you may want to institute for your salaried employees is letting them know that their hours are based on up to 44 hours a week. And the Employment Standards Act also allows employers to average weeks. So for example, employees might work more in 1 week. Maybe they work 45 hours 1 week and only 30 hours the next week, or a shorter amount. And so you're not necessarily paying overtime for the first week. You could average the 2-week period and determine whether or not there should be overtime payable. So in this particular situation with averaging, overtime would only be payable if there was the employee worked over 88 hours in that 2-week period. And averaging is a wonderful way if you have like sort of uncertainty and dips up and down in the requirements for employees to work. You can be able to average and not necessarily be on the hook for overtime, whether it's exceeding the 40 hours, if that's what you've established as your work week, or going over the 44 hours. Now, again, as I mentioned, that it has to be in writing to be able to allow employees to go work overtime, and overtime has become a very contentious issue. So I always recommend that employment contracts clearly state that employees might work up to a certain amount of hours or might exceed the weekly maximums, and that for purposes of overtime, any overtime pay will be averaged over a pay period, so that could be a 2-week pay period. And also, if you want employees to be able to take paid time off instead of actually paying them the overtime hours, that is permitted, but again, only if there's a written agreement. So ensuring that your contracts basically say that employees can be able to take paid time off instead of actually get overtime. Overtime classification is a big issue as well. There are a number of employers who think that just because an employee has a certain level in an organization, so maybe they work in a capacity as a tester and they're making $75,000 to $80,000, so they're a web developer tester, let's say, they're not going to have to be subject to overtime. But that, in fact, is not true. There are very clear prescribed exemptions within the Employment Standards Act, and if the employees don't meet those exemptions, that means that overtime pay should be paid. So there are a number of exemptions. If you have questions, do contact me. I'll be able to discuss them with you. But some of them are managerial exclusions. So if somebody's a manager or doing manager type work, they would be excluded from overtime. But if you have somebody who's in a marketing role and they might be quite senior, and they're not managing a group of people, but maybe even managing a process, they might still be subject to overtime. So you'll want to make sure that you're very clear about who's exempt in your organization and who's not. And if there is a employment standards inspection, you can easily point to who's exempt to overtime and who would be paid overtime and have their hours of work there. Now that covers some of overtime and hours of work. I'll now look at vacation pay and vacation time. And for those of you who have read my blog post, you'll hopefully be able to answer the new poll question that I have. But for those of you who haven't, you'll get a piece of information if you haven't already known it. So with respects to vacation, some areas that employers have difficulties under the Employment Standards Act, or I guess fail to appreciate under the Employment Standards Act, is that the vacation pay and vacation time is really two separate entitlements. Employees are entitled to vacation time at minimum of 2 weeks per year. And that is time that they can take within a 12-month period of work, which is called a vacation entitlement year. Now, your vacation entitlement year doesn't necessarily have to be a calendar year. Typically, under the Employment Standards Act, they assume that it's when the employee starts work with the company, but obviously that would be very difficult for an employer to be able to manage, to have different vacation entitlement years. So the Employment Standards Act does permit employers to have a fiscal year as the vacation entitlement year, and employees would accrue vacation accordingly. Employment Standards Act does say that the employees' vacation entitlement year that aligns to their start date, they're not technically entitled to vacation that first year. They have to actually earn and accrue vacation, but most workplaces allow employees to accrue on a monthly basis and use a vacation as they've accrued it. Now, vacation pay is a separate entitlement. It is 4% of gross wages. And of course, wages, as I've mentioned before, is not only your actual pay. It could be commissions, it could be bonuses. It doesn't include tips and gratuities, discretionary bonuses, or any payments of expenses, but it could also include non-discretionary bonuses, any type of overtime pay or holiday pay, and also would include any other allowances the employer might provide, such as room and board. So wages is very broad, and employers should be paying 4% of the employee's gross wages as their vacation pay. Typically, I say for employers, you should have some kind of accrual that you can show on the employee's pay stub that itemizes the amounts that have been accrued for vacation, and also be able to track very clearly the amount of vacation time employee has taken. As far as vacation pay, employers can do a few things. They can add a particular percentage to the employee's paycheck. So, for example, if an employee is entitled to 2 weeks of vacation, they can pay that 2 weeks on the employee's pay. And then when the employee takes the vacation time, it's taken as unpaid time. The employer can also pay the vacation pay. So whatever has been sort of built up in this bank account, the accrual, they can pay the vacation pay when the employee takes their vacation time, or they can pay a lump sum at the completion of the vacation entitlement year. So the employee would take unpaid time, and at the end of the year, they would just pay out the remaining vacation pay accrual. With respects to vacation pay, I had a client that had always provided for their part-time employees vacation pay directly on the hourly salary, but that wasn't itemized at all on their pay stub. And of course, when they had a Ministry of the Employment Standards investigation, they were found to not have paid vacation pay, even though it was known that the vacation pay was included. So always make sure it's a separate itemized list. You can have, and you should have, a vacation policy that not only establishes a process for employees requesting and obtaining approval for vacations, but also having some kind of use it or lose it framework, so employees can't continue to keep their vacation. And this is important because oftentimes employees are entitled to more than their employment standards minimums. You might give an employee 5 weeks of vacation. And if you have an accrual at the end and you've been providing this accrual, the employee might be entitled to a payout of that particular accrual. What I suggest to employers is that they have a use it or lose it. They can continue to maybe bank their statutory amount, so that is only the 2 weeks of time. So if they've taken less than 2 weeks, they can bank that time, and they have to use it in the following years, or the following year. But their vacation pay would be paid out at the 4% level at minimum at the end for whatever they didn't use. So making sure that you are not necessarily creating a greater obligation for yourself. And also, with respects to vacation policies, there's nothing wrong with having a mandatory time where your office closes and employees are forced to use vacation, because employers are entitled to dictate when employees can use vacation. So if there are blackout periods where employees are either not allowed to take vacation, or there are periods where you're closing the office down and you're forcing employees to either use their vacation time or take unpaid leave, you should make sure you have that in your policy as well. And last thing I'll look at is termination. And I will talk about record keeping and best practices, but termination is another area that the Employment Standards Act can sometimes trip employers up. So one issue is that employers assume that the Employment Standards Act is the employee's only entitlement to notice of termination or severance pay if severance pay is applicable. And that is absolutely not true. If the employer does not have an employment contract with the employee that specifies that at termination, the employee will only receive termination entitlements in accordance with the Employment Standards Act, then the employee is entitled to a greater right or benefit under the Employment Standards Act, and that's assumed as part of their contract. So in this particular case, employee, if they don't have a Employment Standards Act provision in their termination provision in their contract, then the employee would be entitled to common law notice. And as for those of you who know, common law notice is considerably much more high than what is paid out under the Employment Standards Act. In the Employment Standards Act, notice is 1 week for each year of service to a maximum of 8 weeks. And statutory severance is 1 week for each year to a maximum of 26 weeks. However, under the employment standard or under the common law, an employee could be paid out something far greater. So if you have a project manager who's been working with you for 2 years and they're terminated, under the Employment Standards Act, they would only get 2 weeks, but under the common law, they could get something as high as 6 months or even more. So it's very important to know that your contracts are limiting you to the ESA, and if you wish to provide a greater benefit, you're entitled to do so. The other thing under the Employment Standards Act is that the just cause standard is very high. So oftentimes in workplaces, employers will terminate an employee for just cause, decide that they're not going to pay them anything because they believe the employee is the one that's breached the employment agreement. And just cause is for insubordination, lateness, maybe absenteeism, something that the employer sees as egregious. But the Employment Standards Act says that you can only use a just cause and not pay at least the ESA minimums for willful misconduct, disobedience, and willful neglect that is not of a trivial nature and that hasn't been condoned by the employer. So the standard is very high, and oftentimes you'll see that even though you might think you have just cause at common law, and a common law judge would say, yes, absolutely, you had no choice but to terminate this employee and not pay them anything, under the Employment Standards Act, that particular scenario for which you seek to rely on might not be enough to be trivial, and you might still be required to pay employees Employment Standards Act entitlements. And the last thing that is an issue is temporary layoffs. Oftentimes, there might be issues within your workplace that will cause you to have to lay off employees. And this might be in jobs that might not even be seasonal. For example, you might have an act of God happen within your workplace, a fire or a flood, or something that limits an employee's ability to come in for a particular period of time. And employers should always make sure that they have a layoff provision in their contracts, because the Employment Standards Act provides for a layoff. But if it's not in your contract of employment with the employee, then it's considered a termination under the common law. and the common law then will give the employee all the entitlements that they would have either pursuant to contract or the common law. So if you have to close your workplace for a week and you have to tell your employees, look, you can't come in because we had this major flood, some employees might treat it as a constructive dismissal, and they'd be entitled to do so unless you have a layoff provision in your contract of employment. Now, some best practices, just to review what we've talked about, and again, I will be providing a tip sheet that discusses the best practices. Make sure that you have employment contracts that state the standard work weeks, provide expectations about public holidays if employee is required to work them, and if they can take a substitute holiday. Any hours of work, overtime, and overtime pay if you're looking to do averaging, or if you're looking to establish a work week that's longer than, let's say, a 40-hour work week. You should make sure you have a termination and layoff clause. And one best practice is that all employees are required to have copies of the ESA posters and the hours of work and overtime information sheet if you're looking to average or make employees work overtime. And I always say that you should include it as an attachment. There's electronic copies that are available online with the ministry with any offer letters that you send out to employees. If you have employees that have been working for you for a long time and you haven't provided them with these particular posters, you might just wish to do a blitz where you can give them their posters either included in a pay slip or at all hands meeting or something, so they have it and you can comply with the ministry's requirements in terms of making sure every employee has a copy of the ESA poster. Now, other best practices with respects to compliance, you'll want to make sure that you have a poster that's posted on site at the workplace. So whether if you have virtual employees, whether it's a mail room where people can pick up their mail, or if it's employees who work in a particular area, it is at the break room or cafeteria or something like that. So you have ESA poster that's prominently displayed. I always say that you definitely should make sure that you've gone through looking at your job descriptions and classified all your jobs as whether they're overtime exempt or whether or not they are subject to overtime. And that you should always keep records of the hours worked for the non-exempt employees. So these are the people who would be entitled to overtime. You want to have a very clear record of the hours that they work on a weekly basis. You'll want to make sure that you're properly tracking the vacation time that's accrued and also taken by the employees, and the vacation pay that's been paid out, also accrued and paid out. And wage statements as well too. Some employers, you'd be surprised, don't provide wage statements. You absolutely have to provide employees with wage statements, and all of those records have to be held for 3 years. Now, just concluding, one last thing I want to talk about is a few legislative changes. The first is with respects to tips and gratuities. There has been a change as of June 10th. Before, employers were able to withhold some parts of the tips and gratuities that they collect for spillage or breakage or something that the employee might have done. Now, the Employment Standards Act has put rules on the way tips and gratuities are treated. So employers cannot they're not allowed to take, withhold or make deductions unless they're required by law to do so. So if there's a court order, let's say for some kind of child support or something like that, or if they're administering a tip pool, so they're allowed to collect it and then redistribute it amongst the employees who would be in that particular tip pool. Now, managers are not allowed to be part of the tip pool, and if they are part of the tip pool, they have to be a director, sole proprietor, partner, or shareholder in the business, and they actually have to spend some time doing the work, which is part of that particular tip pool. So if they're a hairdresser and they're actually still doing hair and they own the hairdressing shop, they can participate in the tip pool. But if it's for first choice or something, they wouldn't be allowed to do so. And remember, tips are anything. They can be cash, they can be amounts that have been left electronically by debit or credit, and even payment charges if you're a banquet hall and you're looking to have a charge that you levy against people who are using your services. And if you are doing that, remember that you can't pass on those service charges that you might pay for debit or credit onto the employee with their tips. So if that's an issue, you want to make sure that tips are paid in cash. So with that, what I will do is see if there are any questions. And I have one for Tracy. She says, I have a few from Tracy. How do you pay the stat holiday pay when they are on leave and not being paid? So stat holiday pay when an employee is on a leave is only, again, if the employee is on a leave and they've worked in the 4 weeks prior to that stat holiday, then you would have to provide them with the stat holiday pay based on that calculation. However, let's say that the stat holiday happens at a time when the employee has been off, they haven't received any pay. In those circumstances, the employee doesn't get stat holiday pay, but they're entitled to the stat holiday. So they're entitled to a substitute day. They don't lose their ability to have the day, to have the day off. And then what type of written agreement do you need for employers to take their overtime later? I say that you can have that in employment contract, a general statement that basically says with overtime that employees, as an employer, you might be required to work in excess of the standard work week. You should say what the standard work week is. And it can also make a statement that, you know, in lieu of overtime pay, you are able to take an alternate day of work. And that should be fine as far as the ministry purposes. Understand also, though, that the employer can only keep those agreements for 2 years. So it's always good to update your employment contracts by any stretch. So that might be something that you look to do as a way of practice. But if not, if you're not updating your employment contracts, making sure you have something on file every 2 years where the employee is agreeing to that overtime provision. And the last question I have is, do we need to pay out 4% pay from 2015 if they leave in 2016? So absolutely, employees can give up their right to overtime time. Not overtime, sorry, the vacation time. They can give up their desire or ability to take vacation time, but they can never give up their vacation pay. So if an employee has accrued vacation pay at 4% in the year 2015, and they resign or they're terminated in 2016, as an employer, you would have to pay them that particular vacation accrual. So the vacation accrual would have to be provided to the employee on their final pay, and it has to be paid on, I think it's within 7 days or the last pay cycle if it's longer than 7 days after the termination. So those are all very good questions. If there are additional questions, please do feel free to send them to me via email at info@advocation.ca. And as well, if you have some topics that are burning issues within your workplace that you would like me to cover, I'd be happy to do so. So again, send me the topic. I've received many, and I thank you very much for your participation. It helps me to ensure that I have content that is meaningful for you. So with that, I will conclude, and thank you very much for attending today's webinar. As I say, time is our most precious resource, and I appreciate the fact that you've spent time with me this morning. And I look forward to seeing you next month at our August webinar for Accessibility for Ontarians with Disabilities Act. Thank you very much.